Last Friday, the committee conducted a transcribed interview of a TSA witness whose testimony the committee requested in January. You're familiar with this interview?
Yes, I am.
When the committee attorneys asked the witness whether they had been discouraged from speaking with the committee, both the agency and the department attorney repeatedly refused to allow the witness to answer the question, even going so far as to interrupt when the witness appeared willing to answer. How does the department justify this?
As I told Mr. Micah, the questions were requesting him to discuss what attorneys advised him. That's subject to the attorney-client privilege, so our attorneys asked him not to respond and suggested that we discuss it in a different setting and try to get the committee the information they want. If you'd like, I can answer the broader question that I think they were asking right now.
No, I want to get specific to that so-called attorney-client privilege. It is the practice of the House of Representatives to leave to the Congressional Committee the determination of whether to recognize claims of attorney-client privilege or attorney work product. In this case, there is not a compelling reason to recognize the privilege. Further, I would go on to say, I believe you're intimidating somebody. I believe it's intimidating to have attorneys saying, don't answer that question. I'll go back to my original question I asked you earlier. What is it that you think that we shouldn't be able to see here in Congress?
Well, to this point, it's a long-standing position of the executive branch, going back probably to before I was born, that we will not share attorney-client communications with the legislative branch. I recognize that the legislative branch takes a different position. That's a long-standing dispute between the branches.
What other guidance?
One I can resolve.
What other guidance and directive did you give to the witness prior to them coming and testifying before Congress?
I met with the witness once. It's the only time I've ever met him, and we discussed what to expect in a transcribed interview.
How long did you meet with him?
I don't recall. I believe it was about an hour and a half.
So you spent an hour to an hour and a half with the witness prior to testifying before Congress. What direction or directives did you give him?
I'm not going to discuss attorney-client advice.
The attorney-client privilege, whether we recognize it or not, belongs to the witness, not to the department, correct?
No, we were representing him in his official capacity. We offered him the option of having personal counsel. He chose to use agency counsel, so my client is the agency.
Was he pleading the Fifth?
I was not in the room. I don't believe he pleaded the Fifth at the transcribed interview.
Did anybody in the department, did the department attorney contact you or anyone else in your office during the interview to seek guidance on this issue?
I don't recall. They may have.
What was so invasive about that question or questions that you felt it an imperative to make sure that Congress never heard the answer?
I think the attorney-client privilege is well enshrined in the history of the United States and going back to English common law and generally respected by the courts and the law. So it's not about...
Are you familiar with the anti-gag writer?
I'm not, sir.
You're not?
No.
You're not familiar with the law that says you cannot... You're not familiar with that.
Are you speaking about the law that was the subject?
The writer states that no appropriations are available to pay the salary of any federal employee who, quote, prohibits or prevents or attempts or threatens to prohibit or prevent, end quote, any other federal employee from quote, having any direct oral or written communication, end quote, with Congress.
So, yes, let me correct. I was not familiar with that name for it, but I am aware of that legislation.
The Lloyd-LaFollette Act of 1912. You familiar with that?
Did not know it was from 1912 or by Mr. LaFollette, but I am aware that
I'm assuming that was from before you were born.
I believe it is.
And that was what you stated since before you were born. We will further explore this, but I think you're intimidating a witness. I think you're providing counsel that is inconsistent with the law, and I think as such, anybody who's providing that information should have their pay duly docked, and the government should recover that. Mr. Cummings.
Thank you very much, Mr. Chairman. Mr. Meyer, do you think that you or your office was intimidating any witnesses?
Not at all, sir.
And I take it that is this a standard practice before a witness comes up to talk to them and go over
Yes,
testimony?
and if I may, I might add also that he requested that agency counsel be there. If he were intimidated, I don't think he would have done so.
Did you get any indication did you see anything that would lead you to believe that he was intimidated?
Nothing at all, sir.
I don't have anything else.
And just as the last point there, I wasn't in the room, but what I've been told by staff is he was willing to answer the question. He started to answer the question when counsel jumped in and insisted that he not answer the question. That's what I have a problem with.